Hi everyone, I'm going to be presenting today on the Ben FB case with the Des Moines Independent Community School District, Iowa State Education Agency, and that was concluded on September 26, 2005. Some background information on Ben. Ben was an 18-year-old young man. He recently received a diploma from Roosevelt High School in Des Moines. He excelled all through school and was considered to be a gifted student. His senior year, he even enrolled in the Central Academy, which was a specialized program for gifted students located on the Des Moines Community School District Central Campus at the Papa John Center in downtown Des Moines. And he attended that program in the afternoon to receive college credit. Some behavioral information for Ben. He was never to be considered a big discipline problem growing up. He had some minor issues, including truancy and tardiness. He received psychiatric services since middle school, though, for oppositional defiant disorder and attention deficit hyperactivity disorder, or ADHD, and he was on Ritalin since 1998. In the doctor report, which was included on his school record, he did display aggression, anger, and difficulty with self-control, and that was written in 1998. ODD was improving, and the doctor stated that it was later resolved. He struggled with issues around poor judgment, peer relationships, control and compliance when he was stuck in battles. He was very destructive to himself and others. He didn't know how to get out of battles with other people, and he was impulsively being oppositional. He could not resolve issues calmly or in a timely manner, and he seemed to have a short and hot temper. The altercation on February 18, 2005 included Ben leaving the Central Campus to go to the Papa John Center on February 18, 2005. There, an associate from the Central Campus observed Ben lighting a cigarette outside of the main entrance to the school. Next, the associate did ask Ben to accompany him to the office, but Ben refused. The associate reported the incident to the vice principal, and after checking the entrance area, Mr. Glaw, the vice principal, reviewed Ben's schedule and determined that he was going to be at the Papa John Center in the afternoon. So when he drove there, he arranged to speak to Ben in the hallway. There, he did admit that he was smoking, and when the vice principal asked him to empty his pockets, Ben continued to refuse. As Ben did turn to leave, the vice principal reached with one hand to grab his arm just above the elbow. Ben jerked his arm away, and the altercation became physical at that point. The assistant principal's glasses were knocked off. He had attempted to grab and hold on to Ben, who violently resisted the hold by striking him numerous times and shouting profanities. Ben did break free from the hold and ran from the building. Once he got into the building, a white flask containing alcohol fell from his coat, and the vice principal contacted the principal, Gary McClanahan, who responded by getting into his car to search for Ben. He escorted Ben to the office, where the school resource officer, Sergeant Mark Bazinski, determined that Ben would be charged with public offense and took Ben into custody. Ben was also charged with 4 violations for the Des Moines Community School District, discipline policy, intentional display of disobedience or disrespect, assault and battery, disorderly conduct, and unauthorized possession. The recommendation that was made by Principal McClanahan was to the Department of Student Services for Ben to be considered for expulsion. Expulsion review team recommended that Ben would be expelled for the remaining 13 weeks of the school year and placed in an alternative program to complete the coursework needed to graduate. The superintendent agreed with the review, and the team's recommendation was to expel Ben. This led to manifestation determination. A social worker who had numerous contact with Ben and his parents, they asked for a meeting, and this was to determine if Ben's pre-existing diagnosis of ADHD was related to the misconduct that took place on February. March 3rd, 2005, there was a meeting that was held. The participants in the meeting included Ben and his parents, Principal McClanahan, the school psychologist, a social worker, an educational consultant, a school administrator, and a teacher. The report findings stated that prior to the altercation, which is very important to note, that Ben had no IEP or 504 plan in place. He was receiving services from doctors to address his poor judgment in confrontational situations, his anger management, and impulsivity. There were no behavior goals related to the current behavior. There was a documented history of his behavior, but the school was not aware of this incident where there was an altercation with a minister on a church retreat. And the teacher report stated that he was showing inattentiveness and noncompliance. Continuing with the report findings, when asked the question, is there a pattern of predictability to his behavior? Although the report was marked yes in the explanation, it stated there was no pattern to be identified prior to the incident. If Ben does not comply with the request and adults place their hands on him in an attempt to force him to comply, Ben may react physically. School officials were not aware of the previous incident with the minister and Ben's work with Dr. Hopkins, or that Ben was currently taking medication. Continuing on with questions that were asked, did the child's disability impair the ability of the child to understand the impact and consequences of the behavior subject to disciplinary action? Again, in the report it was marked yes, but in the explanation it went on to state that Ben, his parents, and the staffing agreed that although noncompliance was a concern since middle school, the frequency, intensity, and duration of behaviors at school for the past 4 years had not been significant enough for a referral to the staffing team for intervention. The staffing team did conclude that at the time of the physical altercation, Ben did not understand the impact and consequences of the behavior, and that his response to the situation was affected by symptoms of his diagnosis and ADHD and is being under the influence of alcohol. So getting into the case, when there was testimonies, the parents, specifically mom, stated that she felt that the incident was related to Ben's disability. She contacted the school, but no one suggested an evaluation when he was starting to show signs of behavior. She testified that she had never requested an evaluation and did not feel that he needed special ed services, so therefore she just arranged private services outside of the school. Dad, on the other hand, he did agree that he had difficulties related to ADHD, and his disability did cause him to act impulsively, and that he would have benefited from special ed. The doctor said that he had interpersonal difficulties, but not significant enough to request school accommodations. The testimony from the school psychologist, she testified that ongoing diagnosis of ADHD with an ongoing attention to anger management led the team to its conclusions of both Ben's disability and the relationship between the disability and misconduct. The social worker indicated that her prior discussions with Ben led her to the conclusion that he exhibited very rigid thinking and thinking errors that resulted in a pattern of avoiding accountability. These disabilities impacted his education since thinking errors enabled Ben to justify inappropriate behavior and avoid personal responsibility. The educational consultant, her conclusions were that it led her to believe that the team should address the issues, and the team as a whole, which was absent of 2 members, they established a relationship between Ben's disability and the misconduct. They did not recommend continued placement at Roosevelt and Central Campus, and they recommended an alternative placement with a behavior intervention plan. So this then led to the expulsion hearing. On March 10th, 2005, the Board of Directors of the Des Moines Independent Community School District reviewed the facts, including the manifestation determination. There, they noted that the manifestation determination was not a unanimous conclusion, since there were some members of the team that were not there and that they didn't all agree. There were various proposals for the placement that were presented. The majority favored an alternative placement with a behavior intervention plan for the remainder of the school year. Ben and his parents favored a return to Roosevelt. Officials of the campus recommended expulsion. The board conclusion in the decision that was made, the board concluded that the school was unaware of Ben's diagnosis or the course of any treatment. The fact that Ben has the diagnosis of ADHD does not in or of itself prove that he is impaired by his condition. Ben does not suffer from a physical or mental impairment that substantially limits a major life activity. and Ben was not a disabled student such that he could not be held accountable for his conduct on February 18th, 2005 during that altercation. The decision that was made was to expel Ben, transfer him to an alternative location where he could complete the coursework necessary for graduation. Ben did receive a diploma from Roosevelt, but he was not allowed to graduate with his class. So that was not the end of it. On June 6, 2005, the appellants requested a due process hearing, and there were 3 issues that were identified. So following the expulsion, the appellants filed for a due process hearing, alleging that the Des Moines School District violated the IDEA by taking that disciplinary action. Stated below are the violations of each section that were mentioned. So violations of the IDEA by permitting the administration to override the determinations made by the IEP team on manifestation determination questions. Violation section of the IDEA by expelling Ben from school for the conduct that was a manifestation of his disability, and violating the section by expelling Benjamin from school without providing special education and related services. So the reason for the due process hearing, the parents were requesting declaratory relief, the removal of the expulsion from his permanent record, and covering the cost of attorney fees. So under the IDEA, there is a section regarding discipline of children not yet identified. So the IDEA specifically addresses disciplinary procedures for children not yet eligible for special education and related services. Under the Iowa Administrative Rules for Special Education, Section 281.41.534.1, a child who has not been determined to be eligible for special education and related services under this part, and who has engaged in behavior that violated any rule or code of conduct of the local education agency, including behavior related to drugs or alcohol, may assert any of the protections provided in this part of the local education agency, had knowledge that the child was a child with a disability before the behavior that precipitated this disciplinary action occurred. And so I made this in bold and underlined it because all of these things needed to have taken place before the disciplinary action occurred. So Ben and the IDEA, the appellees argue that none of the 4 deemed to have knowledge conditions of put the district on alert of Ben's potential eligibility. I went on to say that Ben's parents neither expressed concern nor requested an evaluation prior to February 18th, 2005. The minor disciplinary problems prior to the altercation of February 18th, 2005 would not put the district on alert. The appellees argue that disciplinary referral alone does not constitute the basis of knowledge that a student is disabled. School psychologist Deb Hill Davis testified that Ben's disciplinary record did not indicate severe disciplinary problems, and the manifestation determination document indicated that Ben's behavior was not significant to convince educational professionals to initiate a referral for special education eligibility. Without eligibility, Ben and his parents may not invoke IDEA protections, including refuge from expulsion. So the final decision that was made, the recommendation of this team, including school psychologists and social workers, was that no evaluation was conducted and Ben be expelled from school. Based on that recommendation, Superintendent Witherspoon proposed expulsion of the Board of Directors concluded that an expulsion was justified. The Des Moines Independent Community School District and the Heartland Area Education Agency prevail on all substantive issues in this appeal. The expulsion of Ben will remain effective. So the critique, I do agree with the decision that was made for Ben due to the fact that none of this was deemed to have any knowledge or conditions to put the district on alert of Ben's potential eligibility. Below, I have included the Iowa Administrative Rules that go along with that was mentioned before. Lessons learned. It is important to know the differences between discipline of students with and without disabilities. It's important to gain a solid understanding of the IDEA. Know the provisions of an evaluation request. Always keep thorough documentation and have consistent communication with parents. And those are my two questions I will include.